City, Michigan is now in session. The Honorable Brock A. Schwartzel, the Honorable Mark T. Boomstrom, and presiding Honorable Thomas C. Cameron. All persons having business hearing draw near, give attention and shall be heard. God save the United States, the State of Michigan, Honorable Court, please be seated.
Well, good morning, everyone. On behalf of Judge Boonstra and Judge Schwartz, I'd like to welcome you all to the first day of hearing cases here in Lansing. I know we've got a lot of people who are experienced appellate attorneys here, but just as a quick recap, I'd remind everyone to keep your eye on your time. We are very familiar with the facts, so I'd encourage you to focus in on the one or two issues that you think the case turns on. And then finally, if you have a case involving minor children, I'd ask you to not identify them by name to protect their anonymity. This is being recorded. Why don't we start today by calling the first case, People of the State of Michigan versus Mann, M-A-N-N. That's item number 377087.
Good morning, Your Honors. May it please the court, Tim Doman on behalf of Nathaniel Mann. I honestly don't know that I have a whole lot to add by way of oral argument this morning. I think my briefs cover just about everything I wanted to say in this case. Really, the gist of our argument is that a statement only becomes a threat in context, that there has to be direct communication from the defendant to the target. Otherwise, if there's communication from the defendant to a third party, I think there either needs to be the intent that statement then be relayed to the target, or else I think if it's reasonably foreseeable that the statement will reach the target, I think the defendant would likely incur liability as well.
So under your theory, if you had a threat being made on Facebook or social media, that could be a medium through which the threat could be made, correct? Even though it's not direct, the person's not tagged, just disseminating it out in the public like that. But this case in your mind is different because it was made in private.
Correct. I think a statement made on Facebook or any other social media platform, it's reasonably foreseeable at that point, given the breadth of the audience, that it would reach the target by some way or another. So I do think that a defendant in that circumstance would incur liability. And I think that meshes pretty well with Counterman and this idea of recklessness and conscious disregarding the substantial risk that the statement will reach the target and the target will feel fear.
Since you brought up mens rea, what do you think the mens rea is in this case?
Because we're dealing with threats, that gets us to the true threat doctrine under First Amendment case law, which then takes us to Counterman, which is this recklessness idea. So again, I think that dovetails with my conception of this, either direct, intent to relay, or reasonable foreseeable. And I see reasonable foreseeability as somewhat of a synonym for recklessness in this context.
This is probably a better question for the prosecution, but I'm not sure I agree with you. I think the prosecution has a higher burden than recklessness. So I want to walk you through at least my thought, and you can correct me if I'm wrong.
Sure.
The statute uses the word intentionally. I understand where you're getting the reckless disregard. That's coming from the whole First Amendment jurisprudence dealing with true threats. That, as I view it, that's the floor. You can't dip below a reckless disregard for purposes of the First Amendment through true threats doctrine. But the legislature chose a different word. They didn't use reckless disregard. The legislature used the word intentionally.
Right.
So what's the mens rea?
So that, I think, is one of our kind of ancillary arguments at the end of our first brief, where we incorporate, the idea that they used intentionally. That means specific intent. So I do think arguably that could imply a mens rea higher than recklessness, just because of the language of the statute. So yeah, that was one of our, like I said, ancillary arguments. But yeah, I do think that someone who disseminates something over Facebook or something like that, obviously not this case, but I think certainly there's an argument to be made that they could incur liability in that instance. And I don't want to make go farther than needs to be in this case. So I would agree that intentionally has to mean something in the statute, right?
Okay.
So, yeah, the prosecution agrees with us in their brief. They say that the real question here is whether there was an intent to have these statements relayed to the school officials. And as I read the record here, I don't see any evidence that this statement.
So the assertion that the ultimate target has to hear or has to receive this message, that's not in the statute, correct?
Right,
You have to get that from the case law with regard to true threat.
correct.
Okay.
Right. So,
But why can't a true threat be made against X, but I just tell it to, A, B, C, D, E, and F? I mean, it's public.
Mhm.
I tell them, I make what would otherwise be a true threat. And what if X is just completely oblivious to it? Or, what if X is an infant? The infant's not going to understand. And so I guess I don't necessarily see why the ultimate target has to be made consciously aware of the threat for it to be a true threat.
right. So under the, I think Virginia v. Black, the court states that true threats are prescribable because of the fear that they instill in their targets. And so to me, and that's the whole point of a threat, is that you're trying to intimidate someone.
So let's say this, so under your reading of the case law, no true threat could ever be made against an infant.
It's a great hypothetical that I had not thought of, but I think if it's communicated to a parent or reasonably
Well,
foreseeable.
but that parent's not the target. The Lindbergh baby.
Right.
Nobody was going after Charles Lindbergh. They went after the baby. And so, no true threat could have ever been made against the baby. Is that your position?
To be honest, Your Honor, I have not worked through that. I don't want to make an
Okay.
off the cuff response. It's a great hypothetical that I had not thought of,
Law
but.
school in session, Tuesday at 10, a little early.
And I always try to think what questions might be asked, so that definitely was not one that came up, but it's a good way to think to tease through it though. So,
I mean, the case of Watts, where, Lyndon Johnson someone was complaining about the Vietnam War. If I get drafted, the first thing I'm going to do is use my gun against
Right.
the president. Okay. That case didn't turn on the fact that Lyndon Johnson had a subjective fear that this person, that even the people around him didn't take seriously.
right,
That the president of the United States, the target of the threat, was subjectively fearful.
right.
Right. I mean, they could have easily resolved it on that. If your interpretation is correct, that would be an easy way to resolve the case, or at least address it.
Sure. And I think, Watts dealt with a different statute. Obviously, I do recall reading some of the case law about threats to presidents and those types of statutes where that kind of threat is just so disruptive, to national security and other interests that it's prescribable for those reasons and not necessarily because it actually instills fear in the president. So I think those statutes are a little bit different than what we're dealing with here. So yeah, I don't think that distinction necessarily carries the day, and so I think at the end of the day, the question for me is really, is there evidence that my client intended these statements to be relayed to the school officials? And again, this was a statement by a young adolescent in his friend's basement. And given the timeline, it looks like he makes these statements. Mr. Reichel, the friend's dad, really doesn't think a whole lot about it. Week or two later, the Uvalde shooting happens, and all of a sudden it gains, new significance. He decides to report it. So I think, to me, I see these as, expressions of frustration that were blown out of proportion following obviously some, horrific shooting, but that does not make them a true threat at the time that they're uttered.
Do we take into consideration at all the fact that apparently shortly after he made these statements, he went out and purchased a firearm, a shotgun, I believe, and he tried to purchase 2 handguns? Does that evidence factor into whether this was a true threat or not?
I don't think so. So he is charged under a statute, which I think requires some substantial step toward carrying out the threat. And for prelim purposes, we did not dispute that second half of the statute, that we didn't have grounds to file a motion for quash based on that standing alone. But I don't think that sheds light on whether at the time my client made the statements, whether he intended for them to be relayed.
Well, I don't disagree with you. I agree with you that they probably don't have any relevance on whether he intended the statement to get relayed to the principal and I think a police or a security officer, a police
Right.
officer. But in terms of whether it's a true threat or not, it would seem that steps taken to obtain tools to carry out that threat would go to whether it's true or not. I mean, if he just popped off and then, did nothing after that, it would seem that would undermine whether it's a true threat or not. On the flip side, if he went out and purchased firearms, that would seem to go to the question of whether it was true or him just popping off.
Right. And so I don't necessarily disagree with that in the more abstract sense, I guess. But to me, in the way I've conceived the statute, it's really about the intent to relay or the intent that they be relayed. And so I agree with Your Honor that in the more broader sense, what was his intent? Things that he does after can bear on that. But at the time he made the statements, his intent to have them relayed, I don't necessarily know that factors into the calculus here. If there are no further questions, I'll reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Good morning. May it please the court, Matt Way from the Jackson County Prosecutor's Office on behalf of the people. I'm going to try to combine the two questions that Judge Cameron and Judge Schwartzel you asked. In terms of the intentional mens rea and what's in the statute, to me, when I read that statute, the intentionality applies to the communication of the threat, not of the I guess the rest of because the rest of the statute goes on to talk about that the threat needs to be reasonably seen as threatening to human life. So I don't think it applies to the entirety of each element, but it's meant to apply to the communication of the threat. And I think that's consistent with counterman, right? Where the example used in counterman is, friends kind of sitting around and saying, oh, you did that, I'm going to kill you, which clearly isn't meant to be serious or intentional. So that's my reading of the intent element that's written into the statute.
So if this was just the misdemeanor charge,
Yes.
okay. So you didn't have the specific intent because you charged it under B and B requires specific intent, correct?
Specific intent or overt act.
Okay. All right. So so what is the intent? In terms of the threat, does the threat have to be recklessly made or does it have to be intentionally made?
So I think the communication of the threat has to be intentional, right? It can't be,
What's an unintentional communication?
well, and that's part of the struggle with some of these mens rea issues.
Let me walk you through at least how I
Sure, yes.
conceptualized it.
Absolutely.
If you have one student texting another student saying, I'm going to kill you tomorrow, you have to look at what the surrounding circumstances, whether that was an intentional threat or not. For example, if it was, I'm going to kill you tomorrow for being late and picking me up.
Right.
Right. And they're two friends.
Yeah.
Right. That's hyperbole. That's
Absolutely.
inartful, whatever you want to call it. But that is not intentional. I think under a reckless standard, though, if the receiver of that text, a friend were to look at that text and see it, right, and reasonably believe I'm going to kill you tomorrow, right, was truthful, under a reckless standard, you might be getting in front of a jury on that. Right? So it is a statement lacking intent. I'm going to kill you tomorrow, but it is recklessly made and it is reviewed by a third party as being truthful. And it's reasonable for that third party under the surrounding circumstances to treat it as truthful. That's the second part of the statute. I'm not saying you're going to get a conviction, but I think you might get in front of a jury on a reckless standard because that communication was recklessly made versus intentional communication, right? Text the threat itself has to be intentional in the first place, not from the perspective of a third party. That's the only way I can figure out the difference between a reckless standard and intentional standard when it comes to a threat, which almost always are intentional in the first place.
No, and I've struggled with some of the mens rea, especially some of the cases that have come out. You know, in Jackson, we have a lot of prison cases, and I don't know what reckless possession necessarily means, but and that was a
We
recent.
have a lot of odd cases that come out of Jackson, I'll just say that.
Stick around, you'll hear a few more.
Yes. So what I would say in the statute is, the legislature put in the statute, verbally, through other means intentionally threatens to use a firearm, et cetera, if the threat can be reasonably interpreted to be harmful or adverse to human life.
I view that part as the true threat, that it is, but I don't see anywhere in the statute a reckless disregard standard at all. And why I'm particularly focused on that is because the trial court said, yes, it's a reckless disregard standard.
Yeah.
And I'm not sure it matters in this case, but if the jury gets instructed, if we go down your road and the jury is instructed on a reckless disregard standard, I think you're going to have a different problem if there's a conviction.
Sure, and I would certainly welcome, we welcome the court's guidance on that. I agree. I don't think it matters here, especially from an abuse of discretion, probable cause standard. All I mean by that language is the reasonably interpreted to be harmful or adverse to human life. That to me does mean it's somewhat, there's that kind of reads as a reckless standard, how it's being interpreted.
Can I throw one more situation by you too? In this case, we have the defendant making a confidential communication / threat to a friend.
And his father, yes.
Well, I think the father overheard, correct? Was he?
I think he was in the room at the time, but
Probably was in the room, but
right.
Is there evidence to suggest that the defendant was communicating to both the father and the son? Or was it talking with the son and the father just overheard?
That's a good question. I'm not sure enough I don't want to mislead the court. So I would defer to what the record is on that.
Let's assume he's telling a friend and the father overheard.
So let's say we've got the defendant you're going to characterize as a threat. Let's say it's a plan.
Right.
Okay. You've got the defendant planning this event with a friend, and the father overhears the plan. And the plan, of course, is to conduct a school shooting. Is that a threat?
If he overhears just private planning, I think that might be a different scenario. I don't think that's what we have in this case.
I know, I'm trying to work it out because plan and threat strikes me as two different things.
I would agree with the court on that. I think planning, like a private planning and versus communicating a threat is different. I don't think there's any evidence that he was kind of planning this with his friend.
I mean, it's not this case, but I'm not sure I completely agree. I mean, if I'm the supposed target and I hear the plan, that would be pretty threatening to me. So, but getting to the question of what defense counsel brought up, does the target have to be aware for this to be a true threat? I mean, again, if it's just two guys popping off and being frustrated, that, that happens, and we have a First Amendment for a reason. So doesn't the target have to be put into a state of concern or at least know about it for it to be a threat?
So that's what a lot of the case law is, not that they don't have to be aware of. The target doesn't have to be aware of, but
So where's the case law that says what you just said?
I think I have it in my brief. My understanding of the case law, and I'll try to find it in my brief, is that the threat has to be designed in a way that is reasonably likely to be communicated or to reach the target, or and I think maybe a more artful way to say it, especially given your hypothetical, is that maybe the danger needs to, reach the target in some sort of way, in the hypothetical of an infant, right?
The question is
Yep.
whether it has to reach the target or whether the father's enough.
Sorry, could you?
Is the father's hearing of the threat enough? Or, in your view, does that threat eventually have to make it back to the principal?
I don't think it has to reach the principal. I think the test really is there a reasonable likelihood that the father hearing that threat, that the danger that he's threatening is going to make its way back to the school.
So you have to, under your understanding, do you have to have the father there? Let's take the father out of it. And let's just say the defendant tells his friend something concerning like this.
Yeah.
And the friend, hopefully being rational enough, says, yeah, I don't want that to happen, and goes to the authorities. Would simply telling the friend be enough? Where the defendant thought he was telling someone in confidence, but he was telling someone in confidence who had a head on their shoulder and decided to tell authorities.
Yeah, I absolutely think just telling the friend
Okay.
alone is enough.
So you
And
don't need the father there.
no, I think the father just happens to be there. I don't think he's a necessary component of that analysis.
I'm sorry, did you say telling the friend is enough or isn't enough?
Is enough, I believe.
Is enough.
Yes, I believe so, yes. Because he's communicating that threat to a person.
And it doesn't matter whether it makes it back to the school or not. It's a threat that
No,
that is reasonably interpreted as a true threat.
Right, yes, that would be our position, certainly. And I think the nature, there's always a lot of kind of hypotheticals you can throw. You ultimately have to look at the context, the totality of the circumstances. And I think, the defendant's intent here is clear from the statement. He wants to walk at graduation. So him saying, that's kind of implicit in his threat. I think it's more than reasonable, especially from a probable cause standpoint, for the lower courts to have said, yes, this is something that's likely to have reached the school, because his intent in making this threat and taking these actions is to get to walk at his high school graduation. The other question, Judge Schwartzel, that you asked is about the post-threat conduct, and I would just, I do think that's relevant, in particularly if you think about, jury instructions when it comes to intent, what somebody did before, after, or before, during, after an incident. We obviously have a flight instruction. I think that's all consistent with considering that in terms of the defendant's intent and his just general state of mind in this case. Are there any other questions? No. All right, thank you. We would just ask the court to affirm.
I don't think I have anything specifically to say in rebuttal to Mr. Way, but I'm happy to answer any further questions the court has. All right.
So I think
Thank
we're
you, Your
all set.
Honors.
Thank you.
Appreciate it.
Thank you both very much. All right, that matter is submitted. Now turning to item number 2, People of the State of Michigan versus Camacho. That's item number 377125. I believe we have Schrotenborough remote. Let's wait till we get counsel on advance from the waiting room here.
Absolutely. Thank you, Judge.
Mr. Jones, do we have,
We've heard him so many times, I could probably make the argument for him.
why don't we do this? Why don't we, we're going to jump forward to number 3 and.
Hold on.
There we go. There we go. All right. Why don't you proceed? Go right ahead.
Thank you, Judge. Good morning. May it please the court. Jonathan Foreman with the Ingham County Office of Public Defender here on behalf of Dominic Camacho today, asking the court to reverse the lower court here today. I want to focus on 2 primary points today. I'm going in kind of reverse order of my briefing. First is that even assuming that the officer had reasonable suspicion here that an assault was occurring, that reasonable suspicion had dissipated by the time that the request for identification was made and that the contraband was discovered. And that means that the stop was impermissibly extended by the request for identification and is therefore a Fourth Amendment violation.
Was there anything in the audio? Because the police officer didn't testify, correct?
Correct.
It was just that we have the body cam.
Correct.
Was there did the police officer indicate in any way that there was some kind of physical movement or gesticulation in the car, moving arms around, which would suggest that the yelling plus physical movement might imply a fight or some kind of altercation?
I think certainly not.
It was strictly yelling.
It was strictly yelling. That is what the officer told the 2, my client and the driver of the vehicle. And that's all we have for forming reasonable.
You said told, but also your client also acknowledged during the video that was admitted.
Yes.
That there was an argument and the argument was between he and his girlfriend.
Correct. He acknowledged that there was an argument. Correct. Sorry, Judge, I don't want to.
No. And your point is that once he got the explanation from your client as to what the yelling was about, there was no reason for asking for identification or anything else at that point.
That's exactly right. And once he acknowledged, I just had to make sure you 2 weren't fighting in here, and that he said specifically, before asking for identification, he said specifically, it's no big deal. That means there's no further criminal investigation going on here. That means that the stop at that point has to conclude at that time because there's no reasonable suspicion that any criminal activity is continuing. And so I think that's the main question to ask here is what was the officer's mission? And was that mission completed by the time he requested identification? And if the mission was to investigate an assault, he had already said, no big deal, I'm no longer investigating, he didn't say this exactly, but no big deal, meaning I'm no longer investigating the assault. And that means the stop has to end at that point. The mission has been completed. And I think a core question here, a core point here is that this wasn't a traffic stop. The people in their briefing say this was a traffic stop and cite a lot of traffic stop principles. But this wasn't a traffic stop because there was no violation of the traffic code. This was an investigatory stop. And that's really relevant because under Rodriguez, the checking of the identification, checking registration, checking for warrants, all those things that are incidental to a traffic stop are permissible only because they serve the same purpose as enforcement of the traffic code. That's the exact quote or the approximate quote from Rodriguez, is that because those incidental checks serve the same purpose as enforcement of the traffic code, officers can partake in them. But here, where there wasn't a violation of the traffic code, where there's no allegation that there was a violation of the traffic code, there's no proof that there was a violation of the traffic code. This was simply an investigatory stop, same as any stop any Terry stop on the street. And so when the officer determined that this was no big deal, that request for identification impermissibly extended the stop. There's a Ninth Circuit case, Banderos, that I cite in a footnote in my brief, but then I discuss it more fully in my reply brief that I think is on point here, that a request for identification for a person who's not suspected of wrongdoing constitutes kind of that extension that I'm talking about here. And that's consistent with the Rodriguez principles that a seizure may last no longer than it takes to effectuate its mission. So if there's any more questions on that point, I'll move on to my second point briefly, which is that I don't even think it's necessary for the court to reach the extension of the stop issue because I don't think there was reasonable suspicion. Quite frankly, I think my first point is stronger, which is why I'm going in that order. But even assuming that the officer was truthful in what he told Mr. Camacho on scene, I think that hearing screaming coming from a vehicle is not a sufficient reason to believe that, does not provide reasonable suspicion that a crime has occurred.
I want to, maybe it's semantics, but screaming versus yelling does seem to be different. I mean, I think it actually helps your position. Screaming might be a bit more alarming and maybe, maybe that would rise, but yelling, I mean, God forbid we all get pulled over for yelling.
Well, that's the point, right? I suppose that's a fair point, and
And the word used that was admitted was yelling, wasn't screaming.
I apologize for confusing the record there. This was,
Oh, Your Honor's yelling. That's exactly what was going on.
so I don't think either is sufficient, but certainly yelling would not be sufficient because for the reasons I explained in my brief, there's all these kinds of innocent explanations for why a person could be yelling in a car. They could be singing, they could just be loudly talking, that could be their voice. I have a loud voice, I wouldn't want to be pulled over because I'm talking in my car. And so that's not sufficient. There's no sufficient reasonable suspicion here, regardless of whether there's an extension of a stop issue after the reasonable suspicion. I'm happy to answer any further questions, but I think the court understands my two main points here. Thank you.
Counsel, go right ahead.
Yes, may it please the court. Jerry Scrotenboer, Ingham County Assistant Prosecutor for Plaintiff Appellee. No, this was a traffic stop. Let's see. The police officer is out on patrol. He is in his car. He sees another car. For whatever reason, he stops him in traffic. That is a traffic stop. Now, defendant is coming up with a distinction without a difference. Anytime that a police officer has the right to stop a car, he has the right to ask for ID and to ask people to get out of the car. The reasons for stopping a person, let's say for speeding, happen to apply here as well.
Mr. Schrodenberg,
Yes.
question for you. You were not the trial counsel who decided to only admit the video, is that correct?
That's true.
Okay. So here, it seems to me, I'm trying to think about situations where you could have, it's not a violation of the traffic code, it's innocent conduct, but it may or may not rise to the level of reasonable suspicion to make a investigatory stop. What came to mind was a vehicle that is weaving within its lane. Okay?
Okay.
So in that situation, a vehicle weaving within its lane, it may or may not be indicative of drunk driving. It may not be. But I think if that police officer made the stop and then testified at the hearing to explain that I've been an officer for X number of years, I've been trained in alcohol effects on driving, the vehicle never crossed the lane, but I saw it gently weaving back and forth within its lane for X number of miles, X amount of time. This alarmed me to the point where I thought the driver may be intoxicated. Now, that's one situation where they actually testified.
Yes.
What I'm struggling with in this case is that there was no testimony at all. It seems to me that the prosecution made a decision to only introduce the video, and that's what we're stuck with in terms of the motion to quash, or I should say the suppression motion. So here, all we have is yelling.
And that's not even on the video. The video starts after the yelling, right?
Yeah, I'm sorry. All we have here is the officer representing that there was yelling, and as I said earlier, and confirmation of yelling by the defendant. So I'm not struggling with the factual assertion that there was yelling coming from the car. The defendant admitted to it, and the officer said it. Okay, so I'm not struggling with that. But my question is why is that a basis for the stop when the officer didn't offer any basis for the stop other than yelling, which in and of itself is not a traffic violation or criminal. Do you see that's what I'm struggling with is the decision that the APA made in only introducing a video without any context or explanation or taking advantage of the officer's training and experience and just letting it all ride on a video that lacks all context.
Well, it doesn't lack all context. It gives the context itself. Now, the evidentiary rules do not apply to search and seizure questions, which defendant is not contesting that point. The evidentiary rules, and of course, United States versus Maddox, U.S. Supreme Court from 1974 makes that very clear. Now, in this situation, he hears yelling. Yelling by itself is not a crime. It's not a traffic violation. That's right. But under the circumstances, it could be that there is a fight that may occur in the car.
Mr. Schottenbauer, I don't want to use your words against you, but you said under the circumstances. That's what we don't have. We have zero in terms of the circumstances. When my grandmother was alive, she was very hard of hearing. I could have been sitting there yelling to try to say something to her about coming down to see her. And would that be grounds for getting pulled over by the police officer?
Well, that depends. That depends. Let's put it this way. Let's say that we have a guy driving in a commuter-only lane. There have to be two people in the car. The police officer sees a car and sees only the driver. Well, it turns out there is somebody else, but that person is lying down in the back seat. Was there any crime there? Of course not. But the officer had the right to stop. It depends on the situation. And under these facts, he heard yelling, which was confirmed, and that gives the officer the right to look at it, even if merely under community caretaking.
I think maybe to follow up on what Judge Cameron was saying, you said depends on the situation. Earlier you said, under the circumstances, that's all the stuff that we're missing. That's the context that the police officer, had he testified, could have provided of why he was actually concerned about this car. Maybe there was something about the car. Maybe there was some kind of physical movement by the person who was yelling. I mean, I can see situations where yelling plus circumstances would suggest, would uphold a good stop. When all we have is yelling, that seems, we don't have any of the circumstances we don't have in this situation. That's the problem, as I see it.
Okay. If you consider it a problem, you can always remand to have the officer testify. You certainly have that authority to do it.
Thank you.
Now, going over to the other point, once he stops, let's assume it's a proper stop. Once he stops, the reasons for stopping any car apply universally, and no case makes the distinction in a traffic stop situation. And there's no question, at least at the broadest, this is a traffic stop. No case makes defendant's distinction. And the reasons for it to say you got to have identity and to get and the police officer has the option of getting the person out of the car, either in the car or out of the car, is officer safety. Now, I had to leave a little early at my conference, a presentation on officer awareness. And there are all sorts of situations. You never know if this person happens to be a member of, these people happen to be a member of a gang. You don't know. Nihilist or a sovereign citizen, you don't know if they are armed or anything like that. The officer turns around, walks back. He doesn't know if somebody picks up a gun, which incidentally happened to be there, and shoots him in the back. You don't know that. This is officer safety. Defendant is wrong on the point of it was extended too long. No, under the circumstances, the officer had the right to do what he did. If your honors believe that it is not sufficient to stop merely from yelling, yes, we can have a remand and we can put the officer on the witness stand and he can testify to everything. And then you can even retain jurisdiction, and then we'll have a full record if you think that is best.
Why should we do that? I mean, the prosecution had the opportunity to do that in the first place, and they chose not to.
This
We're going to
court
give them a
has done that.
second chance because we want to give them a second chance, or what?
This court has done that many times when a defendant has not exactly asked for an evidentiary hearing, and then the court just says, no, we'd like on ineffective assistance of counsel. And then the court says, we'd like to have that hearing on ineffective assistance of counsel, even though the burden is on the defendant. At something like that, the court has done things like that. The court has the option of doing that. And as far as I'm concerned, well, for what that's worth, it really is sufficient ground for a stop.
Any questions? No. I think we're all
And I
set.
ask the court to affirm.
All right,
Thank you.
Any rebuttal?
Just really briefly on the remand point, this, the motion hearing on this was coming up, or if not over a year ago, coming up on over a year ago at this point. Memories have faded, all of that. The point of these motion hearings and evidentiary hearings is everyone puts their best foot forward, makes their record, and we move forward. And the prosecution did what they thought they needed to do here. And if the court determines that wasn't enough, I would ask that the court not remand, to give this prosecutor a second bite at the apple here. I'm happy to answer any other questions. But besides that, I'm asking the court to reverse. Thank you.
All right. Thank you very much. That matter is submitted. Turning now to item number 3, People versus Harbert, 374977. Were we going to switch 3 and 4? Oh, had we? I could be wrong. Never mind. We
I don't remember talking about that. But.
Okay. Go ahead.
Good morning, Your Honors. Mark Linton appearing on behalf of the appellant defendant in this case. I would just like to take a moment to initially address the People v. Saffold that the court had directed us to address for this case. I think it's clear here in this particular circumstance that the defendant's constitutional rights identified in MCR 6.302B3 were not merely imperfect or an incomplete advisement, but were completely glossed over in this plea hearing. In People v. Saffold, the Michigan Supreme Court has addressed whether a plea should be vacated where the trial court admitted portions of the plea taking requirements.
We hear many, if not all, of the rights that were not set forth, which the record's clear that the trial court just missed a few things. But most, if not all, dealt with trial rights. Witnesses against you, being able to confront them, being able to have a jury consider your guilt or innocence. Isn't it obvious that the defendant understood he was giving up his right to a trial by, in the middle of the trial, saying, I want to take a plea? Well, I guess where is the harm?
The harm is that the requirement is the record has to be clear that the defendant understands his constitutional rights under the court rule. The record cannot be presumed as a waiver from being silent on the record itself. And I refer you to the Boykin v. Alabama case, 395 U.S. 238. It's a 1969 case. In addition, I think the Jaworski case from the Supreme Court required that on the record demonstration that the defendant understood the constitutional rights being relinquished has to be clear. And in this case, the record is silent. Now, you're trying to imply that the defendant should know since he's in the midst of a trial, but again, he's not an attorney. He doesn't truly understand his rights. There was nothing placed on the record regarding his attorney saying, I've already advised him of his rights or anything to that effect. And the rule actually requires that the judge personally address the defendant regarding each and every one of these rights. That was clearly absent in this case, and I don't think that you can find that this is a knowing and understandingly.
So if we were to agree with you, is your client revoking his plea?
Well, at this point, yes, he's asking to vacate the plea and that the case be remanded back potentially for trial or a new plea agreement. I think that gets to the heart of the matter as far as that, what I wanted to address. Is there any questions that any of you have? No? Okay, thank you.
Good morning again. Matt Way from the Jackson County Prosecutor's Office on behalf of the people. I did want to address Saffold as well as just a few points in defendant's reply brief, but I'm happy to answer any questions the court might have first.
Is there any question that all of the rights were not gone through by the trial court when taking this plea?
No, that's clear.
So what do we do about that?
So number one, if we look at Saffold, which and I didn't really address it too much in my brief, and I think I misinterpreted the reason that Saffold was mentioned in the order granting the application. But Saffold's a very similar situation, right? There's a plea in the middle of a jury trial. Our Supreme Court held that despite the the judge not going through each and every right with the defendant, that the judge's instructions to the jury were sufficient to cover that. And that also occurred in this case. If you look at the right against self-incrimination, that is on volume 1, page 281 of the jury trial, where the judge said every defendant has the absolute right not to testify. The right to confront accusers, volume 1, page 273. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. The right to a jury trial is never explicitly referenced as far as I can tell, but obviously the defendant's exercising that right. I don't know that needs to be explicitly.
So if this had been a bench trial, we might have had a problem. But you're saying because it's a jury trial and the jury was explained all of these rights of the defendant, that he was aware of them when he shortly thereafter pled guilty.
I think we would have had an issue on direct appeal. I don't think we do have an issue on collateral appeal because of Ingram. I think Ingram's very clear that this cannot be attacked unless defendant was counselless, not ineffective assistance of counsel. And I did want to just address that real quick, because defendant in his reply brief suggests that Ingram and Howard didn't involve ineffective assistance claims, so that shouldn't bar defendant's motion for relief from judgment in this case. I just note that those two cases didn't decide the issue of ineffective assistance of counsel. I think part of the reason for that is it just never got to that point, right? In the context of a motion for relief from judgment, ineffective assistance of counsel is really the good cause portion. It's not the initial kind of substantive issue that the defendant has to show in a motion for relief from judgment. A few other points. Page 3, footnote 1 of defendant's reply brief. Defendant concedes that the trial court's omissions were harmless and caused no prejudice. And I know the court's not required to accept concessions, but that, I think that's pretty strong evidence that defendant can't meet the prejudice requirement here. And then on page 5, defendant suggests that he's entitled to automatic reversal under chronic, saying this is a structural error, but chronic is a case regarding the complete denial of counsel. It's not an ineffective assistance of counsel under Strickland type of case. And that's consistent with Ingram. If you read Ingram on page 296, our Supreme Court says that only counselless pleas can be attacked collaterally. And that's because those Gideon violations are actually have held to be jurisdictional defects. An ineffective assistance of counsel claim is not a jurisdictional defect. Other than that, I think our brief covers our argument pretty well, but I'm happy to answer any additional questions.
We're all set.
Thank you very much.
As far as the jury instructions, I would note that MCR 6.302B3 requires that the court personally advise the defendant as to each and every one of the rights, the right to the trial by jury, presumption of innocence, prosecutor's burden of proof guilt beyond a reasonable doubt, the right to confront witnesses, the privilege against self-incrimination, and the right to testify or not testify at trial. The jury instructions don't cure that requirement. To address the ineffective assistance of counsel arguments, again, the people cite the Ingram and Howard cases trying to bar the supposed collateral attack, but I think that the court has repeatedly recognized that ineffective assistance of counsel is a valid claim. And in fact, we attached in our reply, or we cite the People v. White case by the Court of Appeals issued on September 16th, 2021, docket number 355897, which specifically recognizes that defects may be challenged through a motion for relief from judgment when ineffective assistance to counsel is alleged. So I think that certainly provides authority or guidance to the court that this is a proper motion or a proper procedure for challenging the plea. So I don't know if you have any other questions or. All right, thank you.
Thank you very much. All right, that matter is submitted. Turning to item number 4, People of the State of Michigan versus Thwaites. It's item number 372892. Now we've got one counsel arguing remotely. I think we have both. Mr. McCarthy, we can see you.
Good morning, Your Honors. Can you hear me?
Good morning. We are waiting for Mr. Schrotenboer. There he is. Okay, we can see you both. All right, Mr. McCarthy, go right ahead.
Good morning, Your Honors. Michael McCarthy, P30169, appearing on behalf of the defendant appellee, or appellant rather, Douglas Bain Thwaites. I appreciate the opportunity to appear before you remotely because I'm in a jury trial today, and this is very helpful to be able to come before the court in this fashion. I will rest on what I wrote in the brief as to the first question I raised and the third question I raised in the brief of appellant. I just want to briefly address what was in the second question. That has to do with ineffective assistance of counsel at the time of sentencing because of a misscoring of the guidelines. And I just want to address a couple of things that were raised in the appellee's brief. The appellee appears to rely on the idea that the scoring for offense variable, I think it's 11, at 50 is accurate because in the pre-sentence report, it says that there were multiple penetrations. But in the testimony given by the complainant that is cited it's included in the brief of appellant, and I believe it's set forth on page 21 of the brief, she referred to one penetration to which she was objecting because she also testified to numerous instances other than this forced penal penetration of her mouth as consensual. And it was just this one.
One moment.
Mr. McCarthy, what is the prejudice, even if we agree with you? The sentence would still be within the adjusted guidelines.
Well, actually, no, because there's the guideline range would have been reduced so that the high end of the guideline would be, I believe it's 30 months less than what was actually imposed. According to the calculation I set forth in paragraph or in support of argument 2.
Okay.
So there's the harm, and whether he, at resentencing, maybe he gets the high end of the guidelines, but it would still be less than what it was that he had imposed. I don't have anything else, but I'm happy to answer questions.
Okay, I think we're all set. Thank you.
Thank you.
Scrutenbohr, go right ahead.
Yes, may it please the court, Jerry Scrotenboer for Plaintiff Ingham County Assistant Prosecutor for Plaintiff Appellee. Now, OV 11. Defendant at sentencing said the pre-sentence report is accurate. That gives the judge the right to consider anything in the pre-sentence report. The victim did not testify that there was only one penetration. She testified to only one, which is sufficient for the conviction, but that does not preclude that there were more. Because the pre-sentence report said there were more, the guidelines were accurately scored, and counsel, therefore, was not ineffective, and I ask the court to affirm.
Any questions? No. I see none. All right, Mr. McCarthy?
Thank you. In rebuttal, I will offer this. I've phrased this or framed this issue as ineffective assistance to counsel. Just because counsel says that he's got no objection to the guidelines, or not to the guidelines, but to the pre-sentence report, that doesn't mean he wasn't ineffective. And my pointing out that the facts actually found by the trier of fact and the testimony of the complaining witness was limited to that one time, then that is ineffective to say that I have no objection to the pre-sentence report. And certainly, and this is what I identified, was where the harm lies is in the scoring of the guidelines, which led to the sentence that I submit. Those guidelines should have been scored at 0. It was a one time instead of having it, and that wouldn't have been scored, the one offense under 11, offense area 11. And then, to have it be scored at 50 because it's multiple times, that just really put the guidelines in a much higher bracket than or cell than they would have been otherwise. And that's the reason why I raised this issue.
All right, any questions? No. All right, thank you both very much. Thank you. That matters.
Thank you, Your Honors.
You're welcome. Good seeing you. Turning now to item number 5, People, the State of Michigan versus Robert Pike. Go right ahead.
Yes, good morning.
Good morning.
Mitch Foster for Robert Pike. So the brief, I raised 3 issues. I will stand on the brief for issues number 1 and 2. I believe they've been fully briefed and all of the relevant facts have been spelled out. And I asked the court to reverse based on at least argument 1, and argument 2 is a issue of the state of the law, which is for a higher court. But in terms of issue number 3, I trust that this court has the CPS records as part of the record on appeal. Neither myself nor trial counsel ever had access to these records.
So based on the CPS, my understanding of your argument based on the CPS reports is that you wanted to be able to determine whether MK had made an earlier disclosure. Is that correct?
Not necessarily. Judge Schwartz, I think I know where you're going with that. The record indicates it was undisputed that there was no previous disclosure. And I think that's the prosecutor's position. But what I'm getting at is it goes beyond that. Because as you know, the statute requires a face-to-face interview with the child within, I think it's either 24 or 72 hours, to inquire as to their safety and well-being. So this wouldn't have been a failure to actually go forward proactively. It would be a response to questioning by a trained investigator, regardless of the nature of the CPS referral. So I guess the referral was for maybe malnutrition or smoking marijuana in the home. But once they're there, they question generally about safety and well-being. So these reports would have required the investigator to ask some question, either do you feel safe, or maybe indirect questions about safety and well-being. But the point is, the defense was never given the opportunity to review those questions and the answers to those questions. And the reason why that's important is because it goes to the right to present a defense. It goes to, okay, well, we know there was no report. That's not in dispute, any report until years later. But what the jury didn't hear is how many times the investigators interviewed this child. And also, it's important because
Why would that matter?
It does matter because there was multiple reports. Only one was given to Judge Hattie for the in-camera review. But it matters because the names of the investigators would have been revealed to the defense. Defense counsel could have subpoenaed them, and the individuals could have been asked, which questions did you ask? What were the answers given?
But that would be true in every instance where there's a CPS report. I mean, what you just said, well, we would have learned the name of the investigator, we could have subpoenaed, we could have asked them questions. That's literally true every time there's a CPS report. But these CPS reports are not given over for a reason. I mean, what you just said doesn't get you out of the fishing expedition realm. What concrete evidence do you believe would have been uncovered if you had been allowed access to those CPS reports?
I appreciate where you're going with that, Judge Schwartzel. First of all, those CPS records are not privileged in terms of the privilege belonging to the individual investigated. They are protected statutorily. So there's a little bit of a distinction there. But in terms of a fishing
that might actually be stronger protection. The legislature has seen fit that these are not provided on a regular basis.
Well, I don't think the legislature has ever said anything about prohibiting disclosure of these to a defense attorney representing a defendant. So I think there's a distinction. They're protected from the general public. They're protected just even from an attorney saying, hey, I want these. But when we already have established as an undisputed fact that there was no disclosure, I think that gets over the threshold of a fishing expedition. And that gets to, okay, why wasn't there a disclosure? And there's a difference between.
But see, that question you could have asked MK and you could have asked the mother.
I will get to that. I appreciate that.
How about you get to that now?
Well, I have a couple things to say to answer that question. So both the mother and MK were witnesses who could have been cross-examined. So the protection and the statutory, from failing to disclose these, like I said, doesn't apply to criminal trials. It goes to the right to present a defense. And the right to present a defense is a constitutional right it's a due process right that overrides certain statutory and privilege rights. So beyond, okay, it's a stipulation or an understanding that there was a delayed disclosure and nothing earlier. But if the names of these investigators were given and the questions were asked, then the attorney could have been more effective at cross-examination. So this goes to the due process, also goes to the Sixth Amendment right to confront cross-examine witnesses. And
how do we know that when there wasn't any questioning on this? I mean, it's hard to tell. There was very little cross-examination, if any, on this topic. And how could we tell? Well, it wasn't as effective as it could have been if there wasn't really anything for us to even compare it to.
Well, I think you're proving my point that the trial attorney was limited because he didn't have these records. He couldn't say, hey, MK, weren't you questioned by investigator A about this? Didn't she ask you this question? And then MK would have said, yes, she did, about safety and well-being. And then the trial attorney could have said, so at the time, you're saying you were sexually abused, and that was, you weren't feeling safe at the time, were you? And of course, she's going to say, no, I wasn't, because I was being sexually abused. But MK, wasn't it true that when investigator A asked you about your safety and well-being, you said X, like, I feel safe, I feel fine? Or
I don't see how almost all of this couldn't have been done with the knowledge that she didn't disclose, which it's undisputed that she didn't disclose and that she had met with CPS several times. I don't see how everything you just said could not have been brought forward on cross-examination, either with MK or, again, maybe, you know, that's not the greatest trial strategy, with the mother. And all of the, you know, never disclosed. Well, why wasn't it disclosed? Did you feel safe at the time? Well, why wouldn't you have said, I mean, all of this could have been explored during cross-examination, but none of it was.
the reason why that I disagree strongly with your analysis is that the more specific information you have, the more effective your cross-examination is. If you ask general questions, it's much easier for a witness to answer a general denial but if you get into the specific, investigator Mary specifically asked you about your well-being living in this household at the time you're saying these things happened to you, and you answered, I felt safe. We don't know what her answers were. We don't know what the questions were. We don't know that. The trial attorney didn't know that. It was impossible for him to be effective on this line of questioning without these specific details. And it's important that every defendant accused of criminal sexual conduct with someone age under 13 has full discovery, full access to these. And it probably shouldn't have even been framed as a stand-away motion. It should have been as a discovery request and a motion to compel discovery. But since we're here under the provision that it was framed, we're going after it under the stand-away and the in-camera review. But either way, the end result is a denial of due process. And not just the specifics that I was getting at in effective cross-examination, but the other reason is credibility. So, MK, wasn't true that you told investigator A, CPS investigator A, that you felt like your well-being was fine. There was nothing wrong. And you told her that. But wasn't it true that that was not true? That was actually a lie. Because as you're saying now, when you're telling this jury, I wasn't feeling safe because I was being sexually abused. So it goes to credibility. And that's the key in this case. It's all about credibility and credibility of MK. So I think it goes to the heart of the issue, the heart of the defense, which was denied.
Thank you.
Thank you.
Good morning. May it please the court, Brandon CCI on behalf of the people. I had a little speech prepared, but I don't want to bore the court, and I want to be respectful of the court's time. And it was mostly dealing with the first issue anyway, so I'll mostly just respond to what Mr. Foster just said. He brought up the right to present a defense, the defendant's due process right. Those are incorporated in the analysis of the Stanaway opinion on which MCR 6.201C is based regarding discovery of privileged or protected records, including the CPS records in this case.
What about Mr. Foster's main point, which is that defense counsel basically had one arm tied behind their back because they didn't have the information needed to make informed inquiry on cross-examination? So
I think, as Your Honor pointed out, the defense could still have cross-examined MK about her and her mother about those CPS contacts. They could have done so. I think they could have effectively cross-examined her with those. I understand that
They couldn't have impeached her though, could they? If her or the mother had said something that was inconsistent with the CPS report.
what I would say to that is that the prosecutor actually did have access to those reports, and the prosecutor would have a duty to correct any false information that was testified to.
I'm not making light of that, but this is an adversarial system. We don't usually want to rely on.
I understand the court's concern there. I think that the ultimate question is whether the defense was able to present a defense or whether they were denied their due process right. They had the opportunity to cross-examine. The court has those records to see whether there was in fact any material that could have been used to impeach MK in this case. And the court can make that determination. Furthermore, they were able to put on a defense at trial, even aside from this impeachment. The defense was able to, raise reasonable. I mean, they could argue for reasonable doubt based on whether the victim was dreaming about these encounters, etc. It's not as though the defense was completely denied their ability to present a defense. I'm happy to make myself to present myself to the court for further questioning. Otherwise, I'm happy to relinquish my time.
We're all set.
Thank you.
Awesome.
I'd like to stress the point one more time about the concern Judge Schwartzel had about, well, wouldn't we be giving these to the defense in every case? And my answer is absolutely yes. And I've tried a few CSC cases myself. And in all of the cases where there was child abuse CPS reports, I was given them as part of the normal discovery without any litigation or even filing a motion, part of the normal discovery process. So that concern I don't think is valid. I mean, all concerns are valid, but I don't think it's backed up by what really happens out there. And in this case, it was denied.
All right, thank you. All right, that matter is submitted. Turning now to item number 6. Benzian Properties LLC versus Elite Professional Management LLC. That's item number 374072.
Good morning.
Good morning.
Mark
Morning.
Ronzaro on behalf of the plaintiff appellant. I do not anticipate taking up too much of your time, so. I
Well,
will
we're here.
reserve
I
the
mean, you
rest
might as
for
well
rebuttal.
take our time.
We don't get to see you that often, Mr. Gonzalo. Go ahead.
You really should see me more often.
Yeah. Fresh from a vacation, I understand.
This is a case of competing quiet title claims and also competing motions for summary disposition on those claims. What I have challenged in this appeal is the circuit court's grant of summary disposition to the defendants. This decision comes down to a very interesting distinction that exists in Michigan law, because I can't say I knew this before working on this case, but there is a difference between a land contract and a contract to sell land. That's what this court decided in the Zercher case.
I'll tell you, my law clerk and I, it took a while for us to wrap our heads around because it just seems like those are the same words put in different order. But is it, from my reading of the case law, maybe the key distinction is whether is that land contracts are payments, are installment payments
Installments.
over time.
Yes.
Because even if you have installment payments over time, there's an implied interest rate in there somewhere, whether it's zero, could be negative, could be positive, but anything over time is going to have an interest rate implied in it. So it's really, it seems like that installment over time, which is critical. And isn't that problematic for you? Because you have two installments. Or you have the installment when they signed the contract, and then I think 3 or 4 months later, you had another $40,000 payment.
That's not my concept of an installment. That's certainly not my concept of how a land contract works.
How
I
many?
mean, installments, it seems to me, the original payment was at the time of the second contract. And then there was only one other payment called for.
How many payments make up an installment?
Well, I think with the S on the end, it has to be plural. That's just a guess
Okay,
on my
so you
part.
have the initial payment, and then you have to have at least 2 additional payments for it to be an
Yes,
installment.
And the question in this case, obviously, is we're at a summary disposition stage. And at the summary disposition stage, is it so clear that this is, in fact, a land contract? That's the whole basis of the trial court's ruling. And the trial court's ruling, interestingly, was more based on not what was in the contract, but what the title of the contract was. And one point to be made about the title is that contract, it does say contract for deed, which we acknowledge is in fact construed in the law as synonymous with a land contract, but it's what's in the contract, not what the title of it is. And even perhaps more importantly, if you look at the Zurcher case, the Zurcher case says there's a difference between a land contract and a contract to sell, to propose a sale of land. And one of the points to be made in my favor is that this, what they're calling a land contract, did in fact incorporate a prior contract, which basically mimicked the same words as Zurcher for the non-land contract. It was called a purchase and sale agreement. So we have 2 contracts, basically. The first, incorporated into the second. And if we're working off titles, if that's all the trial court was only going to get as far as the title, I've got one that's titled as a purchase agreement and one.
So I do have a question. So at the end of the day, you're not asking for double dipping, are you? I mean, you're asking for either the property or the proceeds, but you understand you can't get title plus the proceeds.
Yeah, what you are talking about is remedy. The point that they have made, and there's no denying it, a quiet title is an equitable action, okay? And what you are talking about is the remedy that would ultimately be.
I'm just asking, what is your client asking for? Do they want the property and the money?
Well, that's something that hasn't been resolved because the trial court found as a matter of law that this was a land.
What are you asking for? I mean, that's been resolved. You asked it.
I can go back to the complaint to tell you what he's asking for.
It seems like your client's asking for a lot.
And the question is, does he get what he's asking for? And that's a remedy. And that, of course, has not yet been reached in the case precisely because of this across the board ruling on summary disposition. We've also raised a conversion theory that follows, and there were some other allegations in the complaint, which if my client still has, if we get a reversal with respect to this kind of the distinction between a contract for sale of property and land contract. There are other theories in the case which would come back into play, including, I think, the conversion claim. That one is based on the fact that the insurance company did, in fact, issue a check with my client's name on it, and they cashed it anyway. And that's another one that would be relevant. But the point is, I think in terms of how the judge decided this case, and they made a ruling as a matter of law with respect to this was a land contract, I believe that that is in fact incorrect. Thank you.
Thank you.
Good morning. May it please the court. Craig Federline appearing on behalf of defendants, counter plaintiffs, appellees.
Before we get into this, I know Mr. Granzato wasn't trial counsel. Were you trial counsel?
Yes, I was.
not for nothing, this is maybe the worst copy of a document I've ever seen. It's almost impossible to read that, whatever it's contract for land or whatever it's entitled. So just next time, if someone could ask ChatGPT to clean it up or something, I don't know.
Absolutely. Well, first of all, I'm glad you brought that up, because the plaintiff in this case who filed the case is an attorney at law who drafted the document. And that's why when you read the lower court's decision using equity, interpret that contract against the plaintiff.
I'm not even talking about
Who
the
was
terms
aware.
and conditions. I'm just saying it's hard to read,
Right.
you know, like,
And we agree that even in the lower court, we did not have very clean copies of things. But I think it is important that I am here to answer whatever questions this court has, because I've been practicing in this area for 30 years, doing land contracts and drafting them. And I agree with you that this is not the best drafted land contract in the world, and that's what did cause some of the confusion. However,
what is the contract that we're looking at? Is it?
so it is very important to note, if you look at plaintiff's brief, and it helps, because if you look at Exhibit B, the Exhibit B is the purchase and sale agreement. Nobody has a problem preparing a purchase agreement. It provides that the payment is for $160,000 to purchase this building. It's a commercial piece of building in
It
dilapidated
was made
condition.
with a different party.
No, it was with Jennifer Oliver. She is,
Right, and Oliver was not the person who entered into the contract for deed. She signed on behalf of an LLC.
correct. But it also says, if you see, this is very common language in a purchase agreement that we draft. It says Jennifer Oliver and or her permitted assignees. So what
I know
happens?
she assigned it, but I'm
Right,
saying
which is very typical. She
she
assigned
entered
it.
into a purchase agreement, and then we have another document entered into by a completely different entity, which I understand was assigned to the purchase and sale agreement.
I 100%
So
understand.
what terms and conditions do we look at?
So the terms and conditions you're looking at is the contract for deed conditions.
Why do we look at that?
Because that is what controlled the case, and that's what controlled the execution of the documents. Okay, the purchase agreement was the original document, which was a simple purchase agreement. You sign when you're buying your house, 160 grand with a down payment, and there's closing. The contract for deed is a land contract. If you look at Cornell, if you go to a real estate course, and you have to understand there's real estate professionals here that go to real estate courses. When you go to a real estate course, they call a contract for deed a land contract. They're synonymous names. So when someone puts contract for deed on there.
The contract itself have a provision that says headings don't matter. And I don't know if the heading includes a title, but it's a heading of sorts.
It is a heading of sorts, exactly. And titles do matter. And the lower court said if
The contract said the headings don't matter. Paragraph 32, they're inserted for the convenience of the parties only and are not to be considered when interpreting the agreement. That's what the contract for deed says.
I agree, and that's fine. And we could go past headings, and that is pretty much a standard clause in most contracts. But in this case, we do have a situation where this land contract or contract for deed provides for a sale property. Also,
What makes it a land contract?
it requires an installment payment.
So, but to Mr. Granzado's point, there's a payment at signing, at execution, and then there's one other. And I think he says that you actually need more than one after the signing for it to be an installment set of payments.
Absolutely not true. I enter into land contracts all the time with my clients for the purchase of a building on land contract. We'll put $150,000 down, and there's a balloon payment due in 1 year of $50,000. And it's not until the 1 year passes and you pay that $50,000 that you get your deed. That's a land contract. It could be one balloon payment.
Well, you said there has to be two payments. There has to be you have to have the downstroke and then also a year later, a second.
Not necessarily. Not necessarily. You could have a 0% zero down and one balloon payment at the end a year later. You still become the owner of record. You obtain equitable interest of the property.
So you're saying you could have a land contract with one physical payment?
Correct. A balloon at the end. It's not at the time of closing, because if it's a time of closing, it's a purchase agreement where your down payment and just have a closing.
But just to be clear, that's not our case. I mean, I think Judge Cameron raises a very interesting case. I'm not sure I agree with you that that's land contract, but at the end of the day, that's not this case, because this case, there were at least two checks or some kind of payment. There was $140 Or it was 160 when they signed the document, and then some months later, there was another 40, correct?
Correct.
Okay,
There were several payments that were made and,
two.
well, actually, there were way
And then
more.
there were after the loss. I get it. I get your point.
Yeah, on page 2 of my brief, there's 6 payments that
There
were
was
made.
supposed to be 2,
Correct.
but there were
6.
Yeah.
And that's just it. And the key language, I think you could also look in this contract, if you look under the contract for deed or the land contract, a very key language there is until the purchase price is paid.
Where are you at?
I'm on page 2 of 11, paragraph 3, which states until the purchase price is paid in full. See that language right at the end? Due on or before July 31st, until the purchase price is paid in full?
Yep.
That is language that is very common in a land contract, and you'll read case law and we'll prepare land contracts that will say, you're gonna buy this property for a purchase price of $160,000, and you're gonna pay the interest rate you pick. It doesn't have to match the amortization schedule. It can be 2% interest, 0% interest, and you'll pay $1,000 until paid in full. It goes on until it's paid in full, $1,000 per month based on a schedule. And if you
understand
fail,
you're sharing a lot of anecdotal information based on your experience handling this, but just in terms of this case, you've got 2 payments, you've got an interest rate, and your position is that that makes it a land contract.
correct. Correct. And I think it's also important for the court to know that there's no dispute that there were 2 separate contracts executed. There was no dispute regarding the balance due, and that plaintiff refused to accept the final tender of payment. There's no dispute that plaintiff did not tender a deed. There was no dispute that plaintiff elected numerous remedies in the court, which is completely wrong. If you're gonna try to waive all the equity that my client had paid in the property, you file what's called a land contract forfeiture in district court. If you want to foreclose on the property, obtain money damages, you file a complaint for foreclosure. And then you have a published or judicial sale or a publication with sale with potential monetary damage between the difference between the sale price and the price sold at sale. In here, it's just a breach of contract claim. And in a breach of contract claim, before you can even bring it, you have to tender the deed. Plaintiff here did none of that. Completely frivolous case. Shouldn't be here 10 years later.
I think we got it. Thank you.
Oh, okay.
All right, Mr. Gonzalo.
What he's talking about in terms of, again, is the remedy. Okay, he's talking about if this is a land contract. I acknowledge if it's a land contract, there are limited remedies available, but that's the whole point we're here to discuss, whether it is a land contract and whether it is correct to conclude that it's a land contract as a matter of law. By the way, in response to your question that was asked of me before, I am told that the property now belongs to Genesee County. So that is not what the plaintiff is trying to realize.
That's outside the record, right?
That is outside the record. You're right. But and there was no interest called for in the contract as well. And again, it's a subtle distinction. But the fact is, this is a contract.
There's an interest rate. It just happens to be.
Well,
zero.
zero is an interest rate. That is provided for in the contract. But
It's a beautiful interest rate. I wish I could get that kind of interest rate. My Dutch accountant wife really wishes we could get that kind of interest rate.
Hey, watch it on the Dutch.
again, my position is pretty clear from the brief. And there are questions of fact that remain. Thank you.
Thank you.
Thank you. All right, the matter is submitted.
Thank
You're welcome. We're moving on to our 11 o'clock call. Do we need to take a break or press forward? Okay. We're going to move on to item number 7, Lafferty versus Sespec. That's item number 373038.
Morning, Your Honors. Kevin Gentry on behalf of the appellant. In recognition of you foregoing your break, I'll be very brief. There is a the question here is whether or not res judicata applies. And here it doesn't, because this dispute could not have been foreseen at the time the judgment was entered. The parties stipulated to Boss Engineering doing something to deal with ordinances. The parties agreed that they were going to do something to deal with ordinances. And then it turned out that the appellees didn't want to do that. So my client sought relief, declaratory judgment. What is the contract? The consent judgment is blatantly a contract. What does the contract say? That's declaratory relief. And probably, other than the case caption, it's going to go before the same judge, same party, same judge. It was a question of whether or not it should be done in this file or that file. And we believe it should have been done in this file because they were asking for declaratory relief. They were not asking for enforcement because the appellees were insisting the contract said something different than it said. So the court has to interpret the contract, not enforce it. That's a declaratory relief of a contract, and that's what we were doing in this case.
Seems straightforward.
Thank you, Your Honors.
All right, thank you.
Appellees. In this case, the plaintiff made a bad deal as he perceives it. He's trying to get out of that bad deal, trying to circumvent the consent judgment in this case.
Let me ask you this. Let's say that there is this consent judgment, and at some point there's a good faith dispute between the two parties who were parties of that consent judgment about one of the terms. How is that ever to get enforced? How is that dispute ever to get resolved if they're precluded from coming forward under res judicata grounds?
There's some enforcement mechanism in the consent judgment.
Okay, what is that?
It binding arbitration. But to answer your question more directly, Judge Schwartzel, I agree with counsel that a consent judgment is in the form of a contract, and the interpretation of that contract would have to be decided by the original judge in the previous action. So it's in the nature of a contract, but it's.
Are we just talking about docket numbers here then? I mean, if they had brought it in a different docket number, would we not be having this appeal right now?
I think that's correct, Your Honor. I think they have to bring it in the prior docket number because it's res judicata in another case.
I mean, I don't want to get crossways with the clerk's office, but this seems like a waste of judicial resources.
What would he file? Would he move to reopen? Would he file the deck action in the same file? What would he, in your view, how should he have handled it?
Yeah, I think he should file a motion to reopen and enforce the consent judgment in the original action.
The failure to do so exposes him to res judicata?
That's our argument, Your Honor.
The only point on rebuttal, just to be clear, it's obvious the court has a good handle on the case. The arbitration provision on page 14 of the consent judgment involved disputes less than $5,000. There's no argument that this dispute here is over more than 20. So the arbitration provision doesn't apply. We belong in circuit court. Thank you, Your Honor.
Thank you. Thank you both very much. That matter is submitted. Turning now to item number 8, Langton versus Orchid Orthopedic Solutions LLC, 375510. Morning.
Amanda Danielewski for the appellant. Good morning. We're here on an appeal from an Ingham County Circuit Court. Judge Stokes granted summary disposition to the defendant based on C10. This is an employment case. It arises out of a claim that Robert Langton was terminated in violation of the anti-retaliation provisions of the Workers' Disability Compensation Act. I think that Judge Stokes impermissibly weighed evidence in granting summary disposition. The key issues in dispute in the motion were causation and then pretext. And I think looking at the Cuddington case that I cited in my brief is helpful because very rarely, and the court said this, very rarely does an employer openly admit to violating a plaintiff's rights or terminating them improperly. And so most cases are circumstantial cases. And it's very easy to pick apart the little pieces of evidence we present and say, well, this isn't enough, this isn't enough. And what I think Judge Stokes failed to do was consider the totality of the evidence as opposed to discounting it, weighing it, assessing a credibility, and then dismissing the case.
So I'm interested in the similarly situated employees.
Yes.
Did you identify any similarly situated employees who were on final warning status for good documentation practices infraction, committed another good documentation practices infraction, but then who was not terminated?
No, but I think that what Your Honor is saying is very significant because what the evidence does show, and instead of weighing that evidence, a reasonable jury could look at the same evidence that you're looking at one way and could look at it the other way.
Well,
There's not a
but
single.
hold on,
Mhm.
hold on. I want to get back to my question. Isn't identifying another employee who was on final warning status pretty important in terms of it could be that you still have a case, but you just don't have any similarly situated employees. Because there was testimony, I think it's unrebutted, that at least defendants say they thought your client being on final warning status was a key issue, was something that was important for them. So for us to compare, if we are going to have similarly situated employees, wouldn't they have to have that same status? Or they're just not similarly situated. Maybe you're a class of one or something.
Well, I think it's more significant that there's not a single employee that was ever fired for a clerical error. Their own policy doesn't even address disciplinary action in that circumstance. And a jury could be suspicious of that when considering all the other evidence in addition.
But again, I don't mean to keep harping on this. I think it would have been an interesting question if you had been able to identify people who were on final warning status, who made that clerical error that you just described, but then who were not terminated. That I think would be apples to apples with your client. But here, if you don't have someone who was on final warning status, I just don't think any of the other employee evidence is particularly relevant.
Well, I do, because there's not a single employee terminated for solely a clerical error. And let me tell you why the evidence that you're asking that we find during the course of the case, if it existed, it wouldn't even be there, because we've established through the facts of the case that the ordinary procedure for addressing this is exactly how it happened before my client said he was going to go off on this extended leave for his surgery. Supervisor talks to you and says, hey, there's an error here. We got to go through the process and we have to correct it. Handled, won't happen again, be more careful. That sort of thing flies under the radar and is a day-to-day event. So the fact that there's no other employee ever terminated or disciplined for making a clerical error is telltale,
Well,
I think.
do we know it's just for a clerical error? And my question, let me back up to ask a different question. Is it clear in the record what it even means to be on final warning status?
No.
Because the initial infraction, as I understand, was falsification.
Yes.
Right? Whereas at least some of the later infractions were clerical or documentation, right?
Yes.
So if someone is on final warning status for a falsification issue, does that mean he's terminated for anything going forward or only for another falsification type issue?
That's a great question. And I think that is going to be something that the jury would assess and decide, is this reasonable? The jury instructions that they hear at the time of trial where you are not to address the business.
Before you kick it to the jury, do you have a sense of what the answer would be?
Well, common sense, and in my experience, employment
You have
law.
a sense based on the evidence in this case, not just.
Is there any corporate policy or anything that explains it?
Well, no, but we look at the policy as it would address clerical errors, and it doesn't even mention disciplinary action. So it naturally follows that a final warning would be another offense that's articulated as an offense. A clerical error, I've cited to their own policy, it doesn't even warn of the potential for disciplinary action. And a jury could be suspicious of that. And I think this argument that we're having about this particular evidence is a weight analysis. Is the employer's articulated reason for firing my client reasonable? And that's the ultimate question for the jury. Here's another example of something that Judge Stokes said on the record. She evaluated a piece of evidence. She said, I don't think it's suspicious that they asked, is there anything else to justify his termination after he was fired and after you asked for the personnel file? When I was in HR, if I got a subpoena, I would make sure the file was complete before producing it. And that's right in the record. Well, that's weighing of the evidence. That's using personal experience to weigh it. I think it's significant. A jury might think it's significant. What else do we have on this guy to justify his discharge? That's one of these little pearls of evidence that the jury can consider. And so we can't weigh that evidence. And so I think all of that is significant. And that's why I think summary disposition in this case was improper. Thank you.
Good morning, Your Honors. Erica Quigley on behalf of Defendant Appellee Orchid Orthopedic Solutions. I'll just take a few things of those in turn that she said. So the clerical error notion, I don't know where this term is coming from. It's not a mere clerical error. A violation of the GDP is serious. So Orchid manufactures medical devices. And the way you document those things, you have to document them properly so they're made properly. And if they're documented incorrectly, there's no way the FDA knows whether it's correct or not. So it's incredibly important to follow the GDP. Any minute violation could cause an issue with patient safety in the long run. So a clerical error, it's not a clerical error. It's
I didn't.
No, go ahead.
interrupt.
Sorry.
I've
Go ahead.
Been interrupting everybody all morning, so I apologize.
It's all right.
En masse. Is it your understanding that there is no evidence of a similarly situated employee who was on final warning status, who made a GDP error or infraction, but then was not terminated? Is that just absence? Is that evidence that is absent from this record?
Yes, Your Honor. And the two defense witnesses for Orchid in this case testified to that. It's basically that he was on a final warning for a GDP violation, and then he committed 4 more additional GDP violations. In the totality, they simply couldn't keep him because it was a risk to the patient's safety. And the circuit court did address that. She mentioned, you don't find in this case that there were others who had similar types of conduct and who were disciplined the same way. There's no evidence of that. And I agree.
Another clarifying question I have. Was it the human resources manager together with the director of operations who were the decision makers here?
Yes, Your Honor.
Okay.
And then I just wanted to quickly address the GDP subsection distinction that plaintiff's counsel brings up. So any GDP violation is subject to discipline. It says that in the employee handbook, or states that a violation of any company policy, procedure, or practice is likely to result in discipline up to and including termination of employment. And his final warning said that any further violation of this policy, the GDP policy, there's no subsection distinction, requires termination or results in termination. And it was the fact that it was 4 additional ones. They kept finding more in October and they just couldn't keep him on. And then I wanted to quickly address the paper trail allegation, the text post termination. Ms. Audis, this is unrebutted testimony. Ms. Audis testified that she sent this text solely in response to a demand letter from plaintiff's counsel that she received on November 14th, shortly before the text, to preserve evidence in anticipation of litigation. She testified to this. There's nothing to refute that. And then the comparable employee discipline note, I already went over it. You know, there's just nothing in the record that someone committed a violation like this, which was a falsification of documentation, and then 6 months later committed 4 more.
Not 4 more falsifications.
Not 4 more falsifications. Nope. It was he didn't input data when he checked something, but he said that he did. And then the other thing was he didn't initial the document. But they have to treat a lot of these violations the same, because if you miss something, it could result in implanting something into someone's body that's incorrect.
Can you answer the question of what it means to be on final warning status and where that's explained?
Sure. It's in the employee handbook and in the common quality manual. So if you're on a final warning, it should say in the final warning what you're on a final warning for. And it says any further violations of this GDP policy are subject to termination. And he testified that he was aware of that. If he committed any more violations, basically on paperwork GDP violations, that he would be subject to termination. Thank you, Your Honors.
Just very briefly in response, I think calling the last 4 incidents a violation is a misnomer. If we look at the policy, these are clerical errors, human mistakes. There is a procedure to correct these as they get noted down the pipeline, right? So this isn't a violation. This is a mistake. He didn't violate a policy. It's a mistake. And we know that violations are articulated in the policy and they warn of discipline. And we've called them pencil whipping during the course of the case, or it's a term of art they use within the shop. But these are clerical errors. These are not policy violations. And so to say that that is the next logical step in the progressive disciplinary scheme is not reasonable. It's not legitimate. And it's just one of the pieces of evidence that I think show that the defendants retaliated against him in violation of the act. Thank you.
All right. Thank you both very much. That matter is submitted. We're going to take a 5 to 10 minute break.
Honorable Court of Appeals State of Michigan is now in session. Please sit.
Well, good afternoon. We are going to resume the docket today with item number 9. It looks like most of the people in the courtroom heard my prior statements to not identify any minor children, but I just remind everyone to do that in the course of your oral argument. So why don't we start with item number 9, Aldridge versus Aldridge, item number 37147.
Aldridge, the appellant in this case. So I think the court first wanted to have the issue of mootness addressed. It is our position that mootness should not circumvent the court from hearing this particular case. Specifically, there's a few reasons for that. The parties in this case put a paragraph in the judgment of divorce recognizing that this appeal was pending regarding venue, and that entry of the judgment of divorce would not defeat or render the appeal moot.
Does that bind us?
It does not bind you, Judge. I'm just making reference that was
Okay.
a paragraph in that.
Okay, we understand. that.
Right.
Yeah.
So
Okay.
parties agreed that this was going on. So we knew that ultimately a judgment would be entered probably prior to entry or this case being heard by the Court of Appeals. So that's why we put it in there.
What's the practical effect? If you prevail, what's the practical effect?
Practical effect is for post-judgment issues. If we have to go back to court, fight over, because there's minor kids in this case, there's 3 minor kids. If we got to go back to court and address issues of custody, change of circumstances, proper cause to change custody, parenting time, child support, the court would still have jurisdiction over those issues, post-judgment issues. And we'd ask that if the court finds that venue was improperly in Ionia County, then it would be in the county that we initially sought to have the case heard in.
Couldn't you seek to transfer venue? I mean, you can do that anytime. There's always something that there's some basis for a change of venue in a lot of cases. I mean, I don't see, regardless of where we come out, I don't see how there isn't an opportunity for one side or the other to seek a change of venue.
Well, I think if a party remains in that county where the court case was initially heard, that would not necessarily allow the venue to change. And then also, I think there's a court rule which says that if the county borders that county, then venue change would be inappropriate too. So it'd only be in those set of circumstances that you'd be able to seek a change of venue in those set of situations.
Isn't there a court rule that governs when there's a post-judgment motion to transfer venue and when it can be granted? I mean, don't we need to follow that court rule?
Yeah, so I believe that court rule, if there's kids involved, if a party's trying to change the venue, I believe if a county borders the initial county that heard the case and entered the judgment, that venue would not be properly transferred to the bordering county. But if for whatever reason, inconvenience to the parties, there's a county outside that border area, then the court can consider it.
What court rule are you referring to?
I don't have it right off the top, but I believe that there is that court rule. I recall seeing that in my past research on the issue. But
as to the mootness issue too, I think that this issue occurs on a regular basis with divorcees. I know in my office, it comes across the table a lot with one party living in one county, one party living in the other county in the county to file in. So I think this is one of the exceptions for public significance for the court to consider this, even though that technically it could be moot. As to the merit of the appeal itself, it's our position that the lower court got it wrong when it made the decision to deny it. I think basically how we set this up is that the Supreme Court has already adjudicated this issue about what the 10-day residency really means, and it's in the Stadamos case, 425 Mich 1 on 1986, where in that court it specifically stated that the 10-day residency requirement is just a jurisdictional requirement for that court within that county to be able to enter the judgment of divorce, similar to the 180-day requirement in the state of Michigan. But when a defendant objects to venue, which my client did here in this case, I think that the venue statute is triggered, and under 600.1621, if the defendant requests that it be transferred, it has to be transferred over to the county where the defendant resides, and that's what we asked the lower court to do. However, it was denied. So I think that the lower court didn't get it right. We'd ask the court today to make a ruling on it and make a determination that when venue is requested by a defendant, that it would be proper to switch divorce cases such as this over to the county where the defendant resides.
Thank you.
Thank you.
Yep.
Voice on behalf of the appellee, Alexis Aldridge. I'll keep this really short. We believe that this is a straightforward application of the statute, the MCL 552.9, which authorizes divorce action to be filed in the circuit court of the county where party has resided for at least 10 days, provided the 180-day Michigan residency requirement is met. The plaintiff, in this case, filed in the county that she was living. She complied with the statutory structure governing proper venue within Michigan's circuit court system. And I think that 552.9 does not remove the authority. Instead, it regulates where the state case is properly filed, which is the hallmark, we believe, of the venue statute. In the Funk v. Funk case, unpublished case, which is just it's non-binding. Obviously, it's persuasive authority. That case never decided venue issue on the merits. They determined that the venue was moot. In Funk v. Funk, the Supreme Court case, Stadamaneros, that was jurisdictional. And that addressed the statutory compliance for entry of the judgment of divorce, not the initial filing location. So I think the main question for this court is whether the legislature nevertheless intended for MCL 552.9 to operate as the statute for determining where a divorce action is to be filed when the complaint satisfies the residency requirements. In those two cases that I cited, they never decided that on the merits. And looking at 552.9, we believe it clearly states it deals with venue, and it should be where it could be where the petitioner or the plaintiff filed her complaint for divorce. And that's exactly what occurred here. We knew this was going to be issued down the road. That's why it was included in the judgment of divorce, although as the court stated, we know that's not binding on the court, our agreement. But we believe that the circuit court judge got it right and kept the venue in Ionia County. And I would ask the court to rely on my brief that we had filed. Thank you.
Okay.
Any questions?
No.
Okay, thank you.
Any rebuttal?
Disagree with that. So the statute of 552.9, it's our position that is jurisdictional, and
If a defendant does not object to the case being filed in the county where he doesn't reside, then that court would have jurisdiction. But the issue arises when there is an objection to venue. And we believe that when that objection is filed, then we got to look at the venue statute of 600.1621. Thank you.
Okay, thank you. All right, that matter is submitted. Turning now to item number 10, TAT-E versus WE4 or IV. That's item number 375928. We have one party who's endorsed. Go right ahead.
Good morning, Your Honors. Robert Burton Harris for Respondent Appellant. I'd like to mostly rely on my brief. What I think this case boils down to is, or the argument is that we believe the trial court abuses discretion when it, by not rescinding the PPO, when the three incidences that underline the PPO were considered and they wouldn't constitute a reasonable cause to believe that prospectively this a violation under the subsection 1 would happen.
What about the tire slashing?
And I think that's pretty much the elephant in the room. The tire,
what?
The elephant in the room, the biggest reason why.
So what about it? I mean, what's the?
So first of all, the tire slashing, assuming that it was actually done by Respondent Appellant, a single instance of vandalism by itself doesn't necessarily mean that is going to occur again. Now, there are some instances where, given the nature of something, or if a person says something while they commit the vandalism.
Well, and I get your point, but I could see where there would be concern about ongoing problems because I think it's reasonable to assume that the tires got slashed because there was a boyfriend or something, correct?
Well, I think that assumption is reasonable. I don't think that was a part of the record, though.
There's nothing in the record about whether there was somebody who stayed the night or that there was a boyfriend or something? Am I remembering it incorrectly?
It was just a friend. There was no specific testimony about the nature of the relationship other than it was a friend who stayed over at the petitioner's house.
Well, it's, we can read into it. Maybe there was something going on there. My concern is that if there was a relationship plus one incident of violence against property, you could see why, if that relationship continues, there might be, motive for more incidences of violence against property. I mean, to get my point, I mean, this isn't just a one-off where, because the relationship might continue, the motive for injury to property might continue.
And I totally understand that kind of framing in that way of thinking. The problem is, or at least for our position, is that the record didn't bear that out. The petitioner didn't express any kind of concern that this conduct might continue in the future based on any of the reasons that you might assume that kind of thing would occur in the future. If there was, and I will say this was,
you're just saying the record's inadequate.
Correct, as to make that specific assumption. And the record was also just kind of confusing for me in terms of the trial court's reasoning, because it seemed to aggregate these three different instances to make them all some kind of indication of a propensity for violence or that the petitioner had a reasonable apprehension that some type of violence may occur. And I don't think that contention was supported by the record at all. Mostly the trial court relied on an assumption. And the assumption was that, well, if this person's tires were slashed, then there was some kind of hard, sharp object. And it's reasonable to believe that the petitioner thought that object could be used against her at some point. And I just think that's just too far of a kind of a jump without some kind of evidence to support that. If there was some threats, in these PPO cases, a lot of time, it's not just one instance. You have a series of text messages, correspondences, a long history of either similar or really, really concerning behavior, like in the Pickering case, like in the other case I cited, I think was Hardeman. So I just, based on this particular record, I think it's insufficient to grant the PPO and continue it, especially given the testimony from the petitioner. And this was not indicative of some type of continuing course of conduct that a reasonable person would fear is going to continue, or at least they should be afraid for their safety or threats or anything like that. Thank you.
All right, thank you very much. All right, that matter is submitted. Turning now to item number 11, CH versus BD. That's item number 376696. We have one party endorsed who I believe is remote.
We'll see.
Yeah, we don't know that they pop up and you.
Okay.
Trying to read today.
Judges, he is in the gallery and it looks like he now is coming to the panel.
Perfect. Thank you.
Wizard of Oz whenever
Yes.
her voice comes over.
Hello, we can see you.
Hello. Good morning. Good afternoon.
Great. If you could just speak up just a little louder and just introduce yourself, please. Can you hear us?
Hello.
Yep, we can hear you. All right. If you, so this is the time for oral argument. You're the only party that's endorsed, meaning you're the only one who is entitled to speak. We're interested to hear what you have to say. You have up to 15 minutes. It doesn't mean you have to use all 15 minutes, but you have up to 15 minutes. We're familiar with the facts. We're familiar with the case, but this is really your opportunity to, and we've read everything that you've submitted, but this is your opportunity to speak to us directly, to share with us any legal issue that you think is important. But again, don't feel as though you have to say anything, but this is your opportunity to speak if you'd like. If you could please state your name.
Okay, my name is
Okay.
I'm filling in the case.
All right, very good. Is there anything you'd like us to know with regard to the legal issues in this case?
Okay, I don't want to like reiterate everything because I feel like my brief pretty much states the gist of everything, but I just want to cover like a couple points. Basically, that the PPO was granted the day that the defendant was supposed to return my daughter from a scheduled visit. It was the first visit that he exercised in a 2-year period. So I was calling for my daughter to just speak to her, check on her safety, which he denied every call. I believe that there's no just for the PPO. There was no harassment, no stalking, or anything of the sort. To or any like legal basis to even continue that PPO. Also, I want to touch on the fact that I was not served that PPO. If it was issued March 3rd, we both went to court in front of the judge that issued the PPO on March 10th, and neither the judge nor the defendant spoke or said anything about a PPO or that it was issued against me. And that wasn't served until nearly 4 months later during a custody decision once my child was back in his care. And I was only served no allegations, but I was only served the restrictions. So basically restrictions of no contacting him, no taking basically my child from his premises, and firearm. No, I wasn't allowed to have firearms and stuff like that. And I just, there's nothing that support those type of restrictions. But that's pretty much it. All I have to say on the matter.
Okay, let me turn to the other judges and see if they have any questions. Do you have any questions? Any questions? All right, I don't think we have any questions. Thank you very much. What we're going to do after this, today, we're going to go and talk about the case, and then we'll be issuing a written opinion relatively soon. Okay?
Okay, sounds good. Thank
All
you.
right, thank you. Thank you. All right, that matter is submitted. Turning now to item number 12. Herman versus Herman, that's item number 378133. I see that no one is endorsed. Therefore, that matter is submitted on the briefs. Turning now to item number 13. Shimmons versus Hare Miners, that's item number 377819. I see no one is endorsed. Therefore, the matter is submitted on the brief. That concludes today's docket. Thank you all very much.